Hello, this is going to be a quick and dirty video. This video is once again sponsored by Bar Exam Drills. Great website to help you prepare for the bar exam. They are the sponsor of my self-taught legal education, along with the Marchica Law Firm in the state of Vermont. They are my supervising attorney, helping me to study for the bar exam. We are coming upon 10 months of self-study for the bar exam, and we're still loving it. So that's a good thing. So today we're going to talk more about evidence. Sorry for all the tabs that I have going on here. This is going to be a very quick and dirty video. Um, Let me just, I don't know if I can easily close this. Yeah, I can. Yeah, so I have so many emails that I'm really trying to clean out my email box, and that isn't working so great. So let me just close a few of these things in our quick and dirty video, and we're just going to talk about in this video the federal rules of evidence. So we've done quite a few videos on the federal rule of civil procedure, but because we just finished level 3 of bar exam drill evidence, we're gonna start an evidence video, and we will continue when we go to level 4, 5, 6, and 7. So let's talk about what evidence is. Evidence is an item which a litigant proffers to make existence of a fact more or less probable. Evidence can take the form of testimony, documents, photographs, videos, voice recordings, DNA testing, or other tangible objects. Courts cannot admit all evidence, as evidence must be admissible under the jurisdiction's rule for evidence. See below. In order to be presented in court, in federal court, evidence is governed by the federal rules of evidence. A court may exclude evidence because it is not relevant, it is hearsay, or it's otherwise inadmissible. Rules of evidence, as the name indicates, are the rules by which a court determines what evidence is admissible at trial. In the U.S., federal courts follow the federal rules of evidence, while state courts generally follow their own rules. See, for example, this is telling us to see California, Indiana, or Washington's. We are actually going to look at Vermont's in the next video. So right now, let's focus on the federal, and then we'll go to Vermont. So in establishing what evidence is admissible, many rules of evidence concentrate first on the relevancy of the offered evidence. See, for example, Article 4 of the Federal Rules of Evidence, the admissibility or hearsay of an oral testimony as addressed in I had to sneeze, Article 8 of the Federal Rules of Evidence. Rules of evidence also allocate among the parties the burden of producing evidence and the burden of persuading the court. See example, Article 3 of the Federal Rules of Evidence, Division 5 of the California Evidence Code. Privileges are addressed under Article 5 of the Federal Rules of Evidence, as well as Division 8 of the California Evidence Code. So this here from Cornell Law School, the Legal Information Institute, is really helping us to focus on California law. So here are the sources to which they got the information from: the U.S. Constitution, Federal Rules of Evidence. Here are some federal judicial decisions from the Supreme Court. We even have some recent decisions on evidence. Let's just look at this really quickly. Take a small segue. Just curious about this. Refusal to pay sufficient evidence of bad faith. When is this from? Supreme Court ruling Fraternal Mystic Circle plaintiff. When is this from? Okay, it's decided 1913. Okay, so that's from a long time ago. I thought maybe some of these would be more current, and maybe they are. Let's look at Reeves v. Alabama. And that was decided 2017. Petitioner Matthew Reeves was convicted by an Alabama jury of capital murder and sentenced to death. He sought post-conviction relief in state court based on, as relevant here, several claims of ineffective assistance of trial and appellate counsel. Among these claims, Reeves argued that his trial counsel was ineffective for failing to hire an expert to evaluate him for intellectual disability, despite having sought and obtained funding and an appointment order from the state trial court to hire specific neuropsychologists. His post-conviction counsel subsequently hired that same neuropsychologist, who concluded that Reeves was, in fact, intellectually disabled. Reeves contended that this and other evidence could have been used during his penalty phase of his trial to establish mitigation. Alabama Circuit Court held an evidentiary hearing on Reeves' post-conviction petition, at which Reeves um, scented substantial evidence regarding his intellectual disability and his counsel's performance. He did not, however, call his trial or appellate counsel to testify. The court denied the petition, and the Alabama Court of Criminal Appeals affirmed. In doing so, the Court of Criminal Appeals explained that a petitioner seeking post-conviction relief on the basis of ineffective assistance of counsel must question his counsel about his reasoning and actions without considering the extensive record evidence before it without considering the extensive record evidence before it regarding Reeves' counsel's performance or giving any explanation as to why that evidence did not prove that his counsel's actions were unreasonable. The Court of Criminal Appeals held that Reeves' failure to call his attorney to testify was fatal to his claims of ineffective assistance of counsel. The Alabama Supreme Court denied review. There can be no dispute that the imposition of a categorical rule that counsel must testify in order for a petitioner to succeed on a federal constitutional ineffective assistance of counsel claim contravenes our decision regarding an objective inquiry into the adequacy and reasonableness of counsel's performance based on the full record before the court. Even Alabama does not defend such a rule. Instead, the dispute here is whether the Alabama Court of Criminal Appeals, in fact, imposed such a rule in this case. I believe it plainly so. For that reason, I respectfully dissent from the denial. Certiorari. Is that how you say that? Certiorari. Anyway, so here we go. This is the Supreme Court case, Reeves v. Alabama, where he tried to say that other evidence should have been used and his counsel was ineffective. So that was a bit of a segue that we didn't need to do, but I just was curious about what it would say. So now we really want to get down into the nitty gritty. Let's just start looking through evidence and see what the rule of evidence says. So here are the federal rules of evidence. These are the federal rules of evidence as amended December 1st, 2020. So we're looking at about 2 months from this being 2 years old. So we can click on any rule to read it. So let's just focus on Article 1 today, the general provisions. Okay, the general provisions. And you know what? I'm going to stop and start a new video. So this video is just talking about what evidence is, an example of a Supreme Court case. The next video will do Article 1, the general provisions of the federal rules of evidence. Once again, thank you so much to Bar Exam Drills for helping me to have a systematic way to study for the bar exam without going to law school and looking for a way to practice law without a lot of debt. And then once again, to the Marchica Law Firm for taking me on as a law office study participant. So thank you so much. Tune into the next video. Goodbye.